Welcome. Thank you for tuning in today to this video about procedural safeguards under the Individuals with Disabilities Education Act, the IDEA. Today I'm going to be talking about some key concepts in the IDEA relating to procedural safeguards and how they protect parents and students who receive special education and related services or are suspected of having a disability but are not yet eligible to receive special education services. I'm going to discuss the Procedural Safeguards Notice, parent participation, access to records and confidentiality of information, parental consent, also called informed consent, prior written notice, understandable language, independent educational evaluations, dispute resolution options, educational placement and stay put, protections for students not yet eligible for special education services, and private schools. I'm going to use the term parent throughout this video. Parent is defined in the IDEA as a biological or adoptive parent, a foster parent, a guardian, and this could be a grandparent, a step-parent, or other relative with whom the child lives, who's authorized to make general or educational decisions, but not the state if the child is a ward of the state, a surrogate parent who's been appointed in accordance with the Michigan Administrative Rules for Special Education, or a person identified by a judge's order. In Michigan, when a student turns 18, all parental rights transfer to the student unless a guardian has been appointed through court proceedings. There are protections in the IDEA to ensure the rights of children who are eligible or suspected to be eligible for special education services when a parent can't be identified, the school cannot locate the parent, the child is a ward of the state, or the child is an unaccompanied youth, meaning not in the physical custody of a parent or guardian, and does not have a fixed, regular, and adequate nighttime residence. The Individuals with Disabilities Education Act, the IDEA, is the federal law governing special education. Congress reauthorized the IDEA in 2004 and most recently amended the IDEA through Public Act 114-95, Every Student Succeeds Act, in December 2015. The IDEA sets the minimum requirements. States can do more but not less. For example, federal law includes eligible students with disabilities 3 through 21 years old. Michigan rules allow for special education programs and services to eligible students with disabilities from birth to 3 years old and extends the age for eligible students without a diploma from 21 to 26 years old. 34 CFR is Title 34 of the U.S. Code of Federal Regulations that governs education. The sections noted here are Part B of the IDEA that refers to special education services. Procedural safeguards are designed to protect the rights of parents and their child with a disability, and at the same time give families and school systems procedures to help them resolve disputes. Rights and protections are found in the Procedural Safeguards Notice. The school must give you the Procedural Safeguards Notice at times when they do certain things or refuse to do certain things as a written explanation of your rights under the IDEA and Michigan Administrative Rules for Special Education. Procedural safeguards protect parents and students by ensuring that schools keep parents informed and provide written notice before taking actions or not taking actions, keep students' information confidential, allow parents to access and review educational records, and follow procedures when changing a student's educational placement. Procedural safeguards ensure parents' right to be involved in meetings to give input regarding their child's education, to request an independent educational evaluation, an IEE, if they disagree with an evaluation that the school conducted on their child, and use dispute resolution options if they disagree with a school decision. Procedural safeguards also provide protections for students not yet eligible for special education services. Schools must provide parents with the Procedural Safeguards Notice, a written document that explains their rights and protections under the IDEA. This notice must be given before certain actions and upon the initial referral or parent request for an evaluation, when the first state complaint or due process complaint is received in the school year, when a change of placement is made due to disciplinary action for a violation of the school code of student conduct, and when a parent requests a copy of the Procedural Safeguards Notice. One of the most important rights under the Procedural Safeguards is a parent's right to be involved in decisions regarding their child's education. Parents are members of any group that makes educational decisions regarding their child, and they have a right to participate in meetings regarding the evaluation of their child, determining whether their child is a child with a disability and is eligible to receive special education and related services, their child's educational placement, developing, reviewing, and revising their child's IEP, and the provision of a free appropriate public education, FAPE, to their child. Schools must take steps to ensure the meaningful participation of parents in the Individualized Education Program, IEP meeting, by notifying the parent of the meeting early enough to ensure a parent can attend the meeting and scheduling the meeting at a mutually agreed upon time and place. Meaningful participation may need to include parent training on technology being used. Schools must take whatever action is necessary to ensure that the parent understands the proceedings of the IEP team meeting, including arranging for an interpreter for parents who are deaf or hard of hearing or whose native language is other than English. And I'm going to talk more about this in a bit. Family Educational Rights and Privacy Act, FERPA, is federal law that protects education records that are directly related to a student and maintained by the school. Each school must protect personally identifiable information of your child. This includes your child's name, your name as the parent or name of another family member, your child's address, information such as your child's social security number or student number, and personal characteristics or other information that would make it possible to identify your child. The school must allow you to inspect and review any education records relating to your child and must do this without unnecessary delay and before any meeting regarding your child's IEP or any impartial due process hearing, including a resolution meeting or hearing regarding discipline. This means the school must allow you to inspect and review the records within 45 calendar days after your request. Just to note that when a student turns 18, the rights of the parents under Part B of the IDEA in general and regarding access to education records are transferred to the student unless a guardian has been appointed for the student. Your right to inspect and review records includes a response from the school to your reasonable requests for explanations and interpretations of the records, your right to request that the participating agency provide copies of the records if you cannot effectively inspect and review the records unless you receive those copies, and your right to have your representative inspect and review the records. The school may presume that you have authority to inspect and review records relating to your child unless advised that you do not have the authority to do so. For example, someone else has a guardianship for your child or through state laws around separation and divorce. A school may charge a fee for copies of records that are made for you if the fee does not prevent you from exercising your right to inspect and review those records. The school may not charge a fee to do a search or to retrieve information for you. If you believe that the information in your child's education records is not correct, misleading, or violates the privacy rights of your child, you may request that the school change the information. The school must decide whether to change the information within a reasonable amount of time of receiving your request. The timeline of what is a reasonable amount of time is not defined. If the school refuses to change the information in your child's records, they must let you know and advise you of your right to a hearing to challenge the information in the records. Prior written notice is a legal requirement of the IDEA. This is a protection to ensure that schools give written information to parents to explain an action the school wants to take or is refusing to take. There are certain times when the school must give you prior written notice, such as when the school wants to or refuses to initiate or change the identification, evaluation, or educational placement of your child, or to change the way it will provide a free appropriate public education to your child. Prior written notice is also required before requesting parental or informed consent for conducting evaluations and the first time your child receives special education and related services. The information in the notice will help you make an informed decision about providing consent. Providing you with written notice should be automatic. Sometimes the school may tell you something in a conversation or in a meeting relating to the issues mentioned above. This does not eliminate the requirement for the school to give you notice in writing with a full explanation of the action they will take or refuse to take. And if you don't receive the written notice, you can request it. The written notice must describe the action that the school proposes or refuses to take, explain why the school is proposing or refusing to take the action, describe each evaluation procedure, assessment, record, or report they used in deciding to propose or refuse the action, explain where you can go to get help in understanding IDEA's laws and tell you how you can get a copy of the procedural safeguards, describe any other options that your child's IEP team considered and why those options were not chosen, and provide a description of other reasons why the school proposed or refused the action. Some specific examples of when you will receive prior written notice are if you request that your child be evaluated and the school says, no, not now. Before your child is identified as a child with a disability under the IDEA, before the school changes your child's educational placement, and anytime the contents of your child's IEP changes. The IEP may be used as part of prior written notice if the document that the parent or student receives meets all of the above requirements. This is a model form of the IEP notice for provisions of services and programs that should be explained to you in detail as mentioned in the last slide. Prior written notice must be provided to you in language that is understandable to the general public and provided in the parent's native language or in another mode of communication that is used by the parent unless it is clearly not feasible to do so. If the mode of communication is not a written language, the school must ensure that the notice is translated orally or in another way in the parent's native language or other mode of communication. There must be written evidence that the parent understands the notice and that the above requirements have been met. Procedural safeguards notice may be sent by email if the school makes that option available. Native language for an individual who has limited English proficiency means the language normally used by the person or the child's parents. The language normally used by the child in their home or learning environment is used in all direct contact with the child, including during the evaluation of the child. For a person who is deaf or blind with no written language, it is the mode of communication the person normally uses, such as sign language, braille, or oral communication. Another important right that parents have is giving or refusing to give your consent for actions that the school wants to take regarding your child's education. Parental consent and informed consent mean the same thing. You may see it written one way or the other. Consent means you have been fully informed in your native language or other mode of communication with all the information for the activity that the school is requesting you give your consent for. It also means that you understand and agree in writing to the activity, and the consent describes and lists what information and to whom it will be released, and that you understand that consent is voluntary and you can withdraw your consent at any time. And think about prior written notice that we just discussed. A full explanation of the action that the school wants to take must be explained to you before you give your consent. While you can withdraw your consent at any time, withdrawing your consent does not undo an action that took place between the time that you gave your consent and when you withdrew it. The school must make reasonable efforts and document these efforts to obtain your written consent before it conducts an initial evaluation of your child, and before it begins providing special education and related services to your child for the first time, and before it re-evaluates your child. Providing your consent for an initial evaluation does not mean that you've given your consent for the school to provide special education and related services to your child. Informed consent will be needed for each of these times after the actions the school is taking are fully explained to you. If your child is enrolled in public school, or you are seeking to enroll your child in a public school, and you have refused to provide consent or have not responded to a request from the school to provide consent for an initial evaluation, your school district may seek to conduct an initial evaluation of your child by using mediation, due process complaint, resolution meeting, or due process hearing procedures. And we're going to talk more about these in a bit. This is called consent override, and it's a procedural safeguard that the school can use to move forward with the initial evaluation or re-evaluation without parental consent. School districts are not required to use this procedure. It's at their discretion. The school can only use this procedure for an initial evaluation or a re-evaluation of a child. These are some additional things to know about parental consent. Schools cannot use consent override procedures if a parent does not want to give consent for their child to receive special education and related services for the first time. Parental consent is needed before personally identifiable information is released to an outside agency providing or paying for transition services. And parental consent is needed if your child is in or is going to a private school not located in the district you live in. Consent must be given before personally identifiable information is released between the private school and the school district where your child resides. When you withdraw your consent for the school to provide special education and related services to your child, the school may not continue to provide services. The school must provide you written notice that they will stop providing special education and related services to your child, and the date that your child's eligibility and entitlement for services will end. Just another note, parents can give partial consent for services only in the initial IEP. Under the IDEA, providing special education and related services for the first time, a school may not use a parent's refusal to consent for one service or activity to deny the parent or child any other service, benefit, or activity. Once the IEP is in place, if a parent revokes services, all services are revoked. Parents can use dispute resolution options to possibly revoke certain services or make changes in the IEP through an agreement with the school. When you revoke your consent, the school may not use due process procedures in order to obtain agreement or a ruling that the services may be provided to your child. Remember the consent override procedures I mentioned a few slides ago. When you revoke your consent, the school is not in violation of the requirement to make a free, appropriate public education available to your child. They are not required to have an IEP team meeting or develop an IEP for your child, and are not required to change your child's education records to remove any reference to your child receiving special education and related services. Parents have the right to disagree with the results of an educational evaluation of their child which was completed by the school. If you disagree with your child's evaluation, the first thing to do is to try to work with the IEP team to make changes. If a parent and the school cannot reach an agreement, the procedural safeguards afford parents other options such as mediation and the right to request an independent educational evaluation, which is like getting a second opinion. The district may grant the request for the independent educational evaluation or initiate a hearing to show that its own evaluation was appropriate. If the district grants the request for an IEE, it is completed at no cost to the parent and is conducted by a qualified examiner who is not employed by the school district responsible for educating the child. The school either pays the full cost of the evaluation or ensures that the evaluation is provided at no cost to the parent. Parents can only request an IEE after the school completes an evaluation and the parent disagrees with the results. Parents have the right to have their child evaluated at their own expense at any time. The IEP team must consider the results of this evaluation if the parent provides them. If the child is found ineligible for special education related services, there are other options under the procedural safeguards. Mediation can be requested, and the parents have a right to file an appeal of the decision of ineligibility through a state complaint or a due process complaint. Your request for an IEE must be in writing, dated and signed, and the school district must respond to your request within 7 calendar days with their intent to provide the IEE at no cost to you or file a due process complaint to request a hearing to show its evaluation of your child is appropriate. If an IEE is requested, the school must provide information to the parent about where an independent educational evaluation may be obtained, how to get reimbursed, reasonable and expected costs, the district's criteria for obtaining the IEE, and that parents can choose their own evaluator. The school may ask what the objection is to the evaluation. However, the school may not require an explanation of the objection, and it cannot unreasonably delay either providing the IEE at public expense or initiating a due process hearing to defend its evaluation. Reimbursement for an IEE that does not meet the school district's criteria may be denied by the school district. If a final hearing decision is that the school's evaluation of your child is appropriate, you still have the right to an independent educational evaluation, but not paid for by the school district. The school must consider the results of an IEE that you obtained for your child that the school district paid for and meets the school district's criteria for independent educational evaluations. The school must also consider an evaluation that you paid for yourself and share the results with the school in any decision about providing a free, appropriate public education to your child. You and the district may use the evaluation as evidence at a due process hearing regarding your child. Parents have the right to disagree with the school about what is best for their child. The IDEA encourages informal resolution of disagreements between parents and school teams. The most effective options involve early and meaningful communication in a collaborative manner. I'm going to discuss options available for you to resolve your concerns that you have. Informal meetings allow you to talk through your concerns and issues relating to your child's education with the IEP team and by reviewing and revising your child's IEP as needed. You can also request a facilitator to lead the IEP meeting process. The neutral facilitator will develop an agenda based on information from the parent and the school and help keep the discussion focused on the issues at hand. A facilitator is not part of the IEP team, doesn't give legal advice, or advocate for a particular position relating to the issues being discussed. You can also use mediation to work together with the school team to resolve disagreements such as eligibility for special education services, transition issues, placement, or communication issues. Mediation does not delay a parent's rights to file a state or due process complaint or request a due process hearing. You can use mediation at any time, even if a state complaint or due process complaint has been filed. The mediator is trained in special education laws and is a neutral third party who does not work for the school district or the Michigan Department of Education. Mediation is a voluntary process and must be agreed to by the parent and the school. The mediator leads the confidential, guided discussion in a neutral environment. Mediation can lead to an enforceable written agreement signed by both parties. Whether there is resolution to the issues or an agreement is created depends on the participants. Special Education Mediation Services, SEMS, helps students by fostering effective teamwork among those who plan their education. SEMS provides free mediation and/or meeting facilitation to help parents and schools resolve disagreements. SEMS is an Individuals with Disabilities Education Act grant-funded initiative that uses trained neutral facilitators and mediators who are not employees of the Michigan Department of Education, the intermediate school district, or the school district. Parents or schools can request a neutral meeting facilitator or mediator through Special Education Mediation Services at no cost. Parties can contact SEMS by phone or fill out a request for services form online. SEMS will gather the needed information about the child, the school, and the issues at hand, and will provide information about how their services may help the situation. SEMS contacts the other party for agreement to participate and will coordinate with the local resolution center to arrange a mutually agreeable date, time, and location to meet. SEMS processes all the necessary paperwork and the parties meet together to resolve the issue. Anyone can file a state complaint when they believe there is a concern about a particular child, including organizations if they believe there is an issue that affects children statewide. State complaints are a written, signed statement that alleges a public agency, such as a school or a school district, failed to implement the Individuals with Disabilities Education Act or Michigan Administrative Rules for Special Education, federal regulations, or state rules related to special education programs and services. An intermediate school district plan, these are the district plans about how they will provide special education services in the district. Michigan Revised School Code as related to special education. Decisions made by an administrative law judge through a due process hearing, or a state application for federal funds. A state complaint must be filed within 1 year of when the alleged violation occurred. Some examples of issues that could be addressed in a state complaint are issues around the IEP, an IEP not being implemented. Under evaluation, the district didn't respond to a parent's request to evaluate. An evaluation was not completed within the timeline required. Around discipline, no services were provided to the child, or there was not a manifestation determination review done. Around free appropriate public education, programs and services for the child were not appropriate. Or around records, the district didn't allow a parent to see the child's records. Issues previously decided in a due process complaint involving the same parties cannot be investigated through a state complaint. And because the state complaint process utilizes the maximum allotted time to ensure a comprehensive investigation is completed, no appeal or reconsideration of the state complaint decision is allowable in Michigan. A due process complaint can only be initiated by a parent or the school. It specifically addresses issues related to violations of the Individuals with Disabilities Education Act or Michigan Administrative Rules for Special Education around identification, eligibility, placement, a free appropriate public education, or discipline, a manifestation determination review decision for a child with a disability. A due process complaint must be filed within 2 years of when the party knew or should have known about the problem. A meeting of the parties called a resolution session must be held within 15 calendar days of filing the complaint unless both parties agree not to have the meeting or use mediation instead. The resolution session is one last effort for the parties to try to resolve the issues without going to a hearing. This meeting must include a representative of the district who has decision-making authority and relevant members of the IEP team. parent and the school determine who is the relevant IEP team member. The school is only permitted to bring an attorney to the resolution meeting when a parent has an attorney present at the meeting. If agreement is reached at the resolution meeting, the parent and the school district must enter into a binding agreement that is enforceable. If the school files a due process complaint, there is no required resolution session. If the issue is not resolved within 30 calendar days of Michigan Department of Education receiving the complaint, a due process hearing may occur. Appeal of an administrative law judge decision in a due process hearing goes to civil court. Generally, your child's placement is determined by the Individualized Education Program team, the IEP team, of which you are a member. The stay put provision under IDEA applies when you dispute the change a school wants to make in your child's IEP. When you invoke this stay put right through a due process complaint requesting a hearing, your child's current placement can remain the same while you work with the school to resolve the disagreement. Stay put means that your child must remain in the current educational placement pending the outcome of the due process proceeding regarding a due process complaint unless the parent and school agree otherwise. In order to invoke the stay put provision, a parent must show they are disputing the change that the school is making by filing a due process complaint or requesting mediation. This action must occur before the change occurs, as documented in the prior written notice that you received from the school about the change. The school can move your child for up to 45 school days, even if you disagree with the move, to an interim alternative educational setting for disciplinary or safety reasons. This decision must follow certain procedures. The assigned interim alternative educational setting is an IEP team decision. During those 45 school days, the school is required to provide services to address the child's behavioral needs. When a parent or the school has filed a due process complaint related to disciplinary matters, the child must remain in the interim alternative educational setting unless the parent and school district agree otherwise, pending the due process hearing decision. There are protections under the IDEA for children not yet eligible for special education and related services. It comes down to whether the school had a basis of knowledge before the behavior that led to the disciplinary action for the child. To explain the concept of basis of knowledge, let's use this example. A student who has not yet been found eligible as a child with a disability under the IDEA violates a school code of conduct. The school takes disciplinary action according to its policies. Before the school takes the disciplinary action, certain people were aware of concerns that the parent, the teacher, the principal, or other school staff shared about the child. Any of these specific actions could have been taken to share concerns. The parent notified the teacher or principal about concerns in writing and said that the child may need special education services. The parent requested an evaluation to determine if the child is eligible for special education and related services, or a teacher or other personnel expressed specific concerns to a supervisor about a pattern of behavior the child demonstrated at school. This is basis of knowledge. The school had knowledge that the child is a child with a disability and is afforded the disciplinary protections under the IDEA. A school district would not have a basis of knowledge if the child's parents had not allowed an evaluation of the child or had refused special education services, or the child has been evaluated and determined not to be a child with a disability under Part B of the IDEA. If the parent requests an evaluation during the time that the disciplinary action is taken, the school must conduct the evaluation in an expedited manner. And all this means is in less than the 30 school days. Until the evaluation is completed, the child remains in the educational placement determined by the school, which can include suspension or expulsion without educational services. If the child is determined to be a child with a disability, taking into consideration information from the evaluation conducted by the school district and information provided by the parents, the school district must provide special education and related services, including following disciplinary requirements under the IDEA. Children with disabilities who are placed by their parents in private schools do not have an individual entitlement to services that they would receive if they attended public school. The IDEA does not require a school district to pay the cost of education, including special education related services, to a child with a disability if the school district made an offer of a free appropriate public education, FAPE, to the child and the child was placed in a private school by the parent. However, the school district where the private school is located must include the child when identifying children whose special education needs are addressed under Part B of the IDEA for children who have been placed by their parents in a private school. If your school district fails to provide your child with a free appropriate public education, FAPE, you might be able to enroll your child in a private school at the district's expense. If you file a due process complaint and the hearing officer agrees that the private school placement is appropriate, the school district may be required to pay tuition for the private school. If the school district made an offer of FAPE to your child and you decided to place your child in private school, the school district is not required to pay the cost of school tuition or the cost of special education and related services. I've just reviewed the key concepts in the Procedural Safeguards Notice. These procedural safeguards are designed to protect the rights of parents and their child with a disability, and it's important to know and understand these rights and protections so you can participate in your child's education. Disagreements with your child's school team will come up. Knowing your options to resolve disagreements will help you advocate for what your child needs to be successful in school. Michigan Alliance for Families is your guide to all things special education. We offer individualized assistance from our 22 regional parent mentors across the state who know their communities and can answer your questions and help you find information and resources. Our learning opportunities are free to parents, students, caregivers, and professionals and are presented year-round. Our library of videos are available for you to access at any time. Please do not hesitate to reach out directly to your regional parent mentor for more information. Follow our Facebook and Twitter. Check out the video library on YouTube and explore the website. Thank you so much for tuning in today, and I hope you have a great day.